Hi there, this is Katherine at Salt and Light Global, here to give a citizen's perspective to all the things happening at our Supreme Court this week. Our justice system was designed for justice, not for this radical weaponization of the law that we keep seeing. Our justice system works best when citizen plaintiffs come before the court and they bring the right question the right way in the right place. And what we've seen from the court in the rulings so far this week is really the Supreme Court holding a high bar and pushing back against the failure to do the basic things right. The first case where we see this is Monday, when the court ruled in the case of the Alien Enemies Act and the White House's enforcement of this law from the 1790s, where they were rounding up people who had hostily invaded our country unlawfully and were harming American citizens, particularly the gangs from Venezuela. And the Supreme Court said that while everyone does have a right to be notified of the charges against them and to actually oppose those charges in court, they must do so in the jurisdiction where they were actually arrested and confined. They can't judge shop and try to find a judge that will throw the rule book out the window and see things their way. They must do this by the book, lawfully in the right way. And so they defended the right of the White House to enforce the law while also upholding the right of individuals who might be here unlawfully to have their day in court, as long as they do that in a way that respects our laws and Constitution. The second case that I'm going to talk about briefly is the application to the Supreme Court of multiple federal union agencies and nonprofits suing the federal government, saying that the President of the United States did not have the right to fire several temporary, non-permanent employees. As the executive officer of the United States, it seems that Article 2 is pretty clear that he certainly has the right to carry out the laws and set up a government that would enforce those laws, to hire people, and also it would seem logically to fire people. But the court didn't even get into those details. They simply said that these unions who were suing because firing 16,000 employees would hurt their membership fees and hurt their dues and hurt their membership clout, the court said they didn't have a good reason to actually come before the court. Your own profit interest is not a reason to tell the federal government that you must employ people just so that it pads your bottom line and fills your membership roster. And so this was a really cut and dry order from the Supreme Court to simply remand this case back down to the lower courts. If these plaintiffs feel they have a legitimate reason to continue their case, they're certainly able to do that. But the court did set a high bar back and say, hey, we need to actually get back to the basics here, do the basics right, and actually pursue justice. I think it was a good ruling. Hope that helps.